Good day, friends. Today we will try to understand the chapter Federalism. In that, what makes India a federal country? This is one of the interesting subject, interesting topic which we need to understand. Already we have understood there are two types of systems. One is unitary, the other one is federal structure of the governance. In unitary governance, there will be only one government at the central level. There will be no other governments at the state level. The central government alone will take care of whole country. In the other hand, we will find the federal structure where at least two levels of governments will be there, which are working at central level and state level independently. And now, what makes India a federal country need to be understood. Here, some of the aspects we need to understand these following points to need to understand India as a federal country. The Constitution of India originally provided for two-tier system. Later, a third tier of federalism was added in the form of panchayats and municipalities. And these local governments have got established in the year 1985, and these different tiers enjoy separate jurisdiction. It is not easy to make changes in the basic structure of the constitution by one level of the government. Parliament or central government alone cannot make any changes in the constitution by itself. And there are threefold distributions of legislative powers between the different levels of governments. And those threefold distribution we can find in the following way. There are three lists of subjects, in which union list is first one, which includes the subjects of national importance like defense, foreign affairs, banking system, communication and currency. Such like this, 97 departments are there which are whole and soul looked after by central government. And these subjects need uniform policy throughout the country. That's why union government alone can make the laws related to these subjects. The second one is state list, which contains subjects of state and local importance like police, trade, agriculture, and irrigation. And such like this, 66 subjects are there in this list. And state governments can make the laws on these subjects, and central government has no right or cannot interfere in these subjects. One more last one is concurrent list, which includes the subjects of common interest to both union and state governments like education, trade, unions, forest regions, marriage, adoption or succession. Like this, 47 subjects are there in this list. Both union and state governments can make laws on these subjects. But if there are some laws which conflict, which are against each other from central government and state government, central government government's law will prevail, state government's law will be cancelled. And our forefathers, the framers of Indian Constitution, were very much talented, and they have foresighted the subjects which we are introducing here in our constitution. There may be some other situations in the future, so that The subjects may appear later in the future of our country, which we do not know. They have made some arrangements for those things also. They have kept the constitution open for residuary subjects, which mean the subjects which are not listed in these three lists, union list, state list, and concurrent list, which are not listed in these three lists, they come under residuary subjects. For example, computer department, computers, software companies, and other things. And on these residuary subjects, union government has power to make laws, and union government alone has something to do in this. That is why we need to understand many more other things. Some special status to states. Some states in India have received special status, and those states, for example, Assam, Nagaland, Arunachal Pradesh, Mizoram. Article 371 of Indian Constitution prescribes about such an arrangement where special status will be given on the basis of peculiar and historical circumstances in relation to the protection of land rights of indigenous people, their culture, and preferential employment in government services. These are the things on the basis of which a special status will be given, and 371 article makes the arrangement for this. The Indians who are not permanent residents of these states cannot buy a land or house or cannot make any property in these states. And some of the regions are such like that which are too small to become an independent state, but which could not be merged with any other existing states. They are too big to merge with other states, or they are too small to make separate state. Such territories are called as union territories. Chandigarh, Lakshadweep, Dadar Nagar Haveli, and Diu Daman, Delhi, Pondicherry, Andaman Nicobar Islands, Jammu Kashmir, and at last Ladakh are the eight such regions which are declared as eight union territories. Central government has special powers in running these territories, and India has independent judiciary, and judiciary plays an important role in overseeing the implementation of constitutional provisions and procedures. In case of any dispute about the division of powers, the high courts and the supreme courts make a decision. The union and the state governments have their power to raise resources by levying the taxes in order to carry on the government and the responsibilities assigned to each one of them. Thank you very much. And these are nothing but the features of federalism which we try to apply on Indian context. To what extent how India is following these features of federalism is the matter, and if we are successful in understanding how India has applied these features of federalism in its governance day-to-day life, that is the matter how India is practicing federalism. Thank you very much.